Hello, I'm Shannon Farrell with the OSU Department of Agricultural Economics, and this is another one of our video modules in the Environmental Regulatory Compliance for Farmers and Ranchers series. Today we're going to talk about water quantity and water quality issues in Oklahoma. Not only making sure that we have access to enough water, but also making sure that we ensure water quality by avoiding any potential problems with water pollution statutes. Now when it comes to acquiring water rights in Oklahoma, we've got a few issues to think about. And there are three basic types of water that Oklahoma water law deals with. The first of those is standing water and diffuse runoff. Standing water and diffuse runoff is the only form of water that can actually be owned by an Oklahoma landowner. And this type of water includes water that's actually standing on the surface of the property and not part of a creek or some other surface water body, but it's actually just standing on the water body before it's actually reached a runoff point. Water flowing over or under its surface before it's reached a definite stream also counts as diffuse runoff. So before it reaches a stream or before it percolates into the ground, it's still standing or diffuse runoff, and that's the type of water we actually can own. If you'd like to see an example of how this might work, let's take a look at this farm right here. If you could see this land in 3 dimensions, you'd see that it slopes downward as you move towards the north, and so runoff from these fields would move towards the north. This landowner could build a dam right here, for example, and capture some of that water before it reached the stream, and that would be standing water or diffuse runoff that could actually be captured and used by that landowner for irrigation or for livestock watering purposes. Now, it is possible to use a stream bed to capture the amount of standing water or diffuse runoff you would be entitled to, so long as you allow the natural flow of that stream to go around the dam that other downstream landowners wouldn't be affected. In Oklahoma, we also have something called the Dam Safety Act that applies to dams that are 25 feet or more in height, measured from the stream channel to the top of the dam, or dams that store 50 acre-feet or more of water. So that really only applies to our larger dams, and most small farm ponds wouldn't have to comply with the act. This overhead view of another portion of the same farm indicates how this might work. As you can see here, you've got downstream water being moved towards the stream beds, and that stream bed then moves towards this area that's been dammed. So the diffuse runoff moves to the stream beds, it's captured by this pond. But remember also that we could negatively impact a downstream owner if we didn't allow the natural flow of these streams to move past the dam. That's why we need a spillway, a runover pipe or culvert or something else to allow for that natural stream flow to take place and move on down to the downstream landowner. One thing we do need to think about if we're talking about damming a stream to capture some of our surface water is the fact that if we cause water to move onto the land of our neighbor, we could potentially have some issues there. So one thing we have to remember is that Oklahoma subscribes to what we call the common enemy doctrine, meaning that a landowner can dam their streams and cause the prevention of flood damage so long as the damage that we move is proportionate to the damage that might be caused to a downstream landowner. And essentially, we have to have a balancing test. We can't make ourselves better off if the point of that is that we make our neighbor worse off. So that's surface water, basically fairly straightforward. Let's talk about stream water. And as we talk about stream water, there are several definitions that we have to take a look at. First off, stream water is, not surprisingly, water that runs in a stream. But a definite stream is something that is kind of, you know it when you see it. A definite stream is generally discussed in our cases as being a cut stream bed with defined banks and a vegetative border, so that you can tell what's a stream and what's the surrounding area. Now, as we talk about definite streams, we also have to talk about riparian landowners. Riparian landowners are landowners that simply own land that's next to the stream. So a definite stream, like we said, is something that looks like a stream and kind of acts like a stream. It's got a defined channel, beds and banks, and it comes from a definitive source of supply. Now, even if we have a stream that only flows intermittently, that still falls under the definition of a stream for the purposes of Oklahoma's streamwater laws. If you look at another portion of the same farm we were looking at earlier, stream water could be a perennial stream. The stream that you see highlighted in blue there is a stream that runs year-round, even though it may not run largely. It does still have a definitive stream through the entire year's cycle of hydrology. It could be a spring-fed stream, even if that stream doesn't run very far, or it could be an intermittent stream, and that intermittent stream might only run when we've had periods of heavy rainfall, and thus groundwater springs are active, or when it's receiving large amounts of runoff from the surrounding area. How do you obtain rights to use stream water or surface water? Well, first off, a riparian landowner can use as much of the as much of the water as they need for domestic use, and domestic use is a term that we'll define here in just a moment, without having to have an appropriation from the Oklahoma Water Resources Board, or OWRB. Now, if we're using water from the stream and we're a riparian landowner, the amount of water that we use cannot substantially or materially injure riparian landowners downstream who also have riparian rights. We can use as much stream water as we need to for our domestic uses, but if that use impairs another downstream landowner who's also riparian, all of our uses have to be reduced proportionately. Anything that we use that's not domestic, even if we're a riparian landowner, does have to have a water use appropriation or a permit from OWRB. So let's talk about what's domestic use of stream water. First off, domestic use includes things like household uses. So things for hygiene, water, drinking, cooking, all those sorts of things are domestic uses. But for example, drinking water that is used by someone else, if we're bottling our stream water, that doesn't work. That's not a domestic use. Watering animals up to the normal grazing capacity of the land is considered a domestic use, but if we have animals over the grazing capacity of the land, for example, if we're trying to water a feedlot, that doesn't count as domestic use. Irrigation of land for orchards or gardens for our own household consumption up to 3 acres, that's a domestic use, but if we're using the water for commercial irrigation purposes, that's not domestic. That's going to require a water appropriation. Lastly, we have de minimis uses, commercial grazing operations, fire suppression activities. Those are all de minimis uses. If we're a business, drinking water for our employees, restroom or hygiene water, and landscaping irrigation, those are also considered de minimis uses. Those don't have to have a permit. But if any of those uses aren't enough, then we actually have to go through the process of getting a water appropriation. So if we're a riparian landowner and we want to use water for non-domestic purposes, that requires an appropriation. If you're not a riparian landowner, if you don't own land next to the stream, then regardless of what the water is used for, you also have to have an appropriation for that as well. And we'll talk about that process right now. How do you apply for an appropriation of stream water? First off, you're going to have to submit an application to the OWRB, and that application will indicate where you're going to take water from the stream. You're going to define where the diversion point is. You're going to then describe how much water you need in terms of acre feet, which is simply the amount of water needed to cover 1 square acre of land to a depth of 1 foot. We're going to say what the water is going to be used for, if it'll be used for crop operations, if it'll be used to water livestock, or if we're going to use it for some industrial purpose. And we have to show the calculations that indicate how much we need by basically justifying the use that we're applying for. Once we've done that, we have to file a notice of the application, and that notice has to be published in the county's legal newspaper. That notice has to run for 2 consecutive weeks, and we have to send proof of the fact that we published it to the OWRB. The point of the application notice is to let other landowners know that the application's been made, so that if they think that the application, if granted, would negatively impact their water use, they can make their concerns known and have that taken into consideration as part of the application process. If OWRB deems that there's been enough interest, we can have a hearing on the application to get more evidence into the record. Once that hearing's been held, and once we have all the information requested in the permit, then OWRB has to make a number of determinations before it can grant the stream water appropriation. Number 1, is there enough unappropriated water available in the stream system to allow the new use? In other words, would we have to reduce the amount of water that other prior appropriations have already received to grant the new use? Second, is there going to be water used for a beneficial purpose? And beneficial purpose is generally fairly broad. As long as we can show the purpose has some societal or economic value, the beneficial use test will be satisfied. Does the use interfere with any existing uses? We've kind of already made that analysis in point A, but point C also shows whether or not explicitly we will cause a reduction or complete obliteration of another use if we allow the new one. And then lastly, will we be transferring water from one stream system to another? And the reason that we have to make that determination is that if it's true, we have to be very careful in making sure that we're not throwing off the water balance between those two aquatic systems. Once we've got a water appropriation, it has to be used or it goes away. The permittee has 2 years to access the water at the withdrawal point once that process has been approved, and if we don't do that, we might lose our appropriation. We also evaluate water use on a rotating 7-year basis. Our minimum use over that 7-year period becomes our new permitted use. For example, if we were given an appropriation of 5 acre-feet per year, and in one of the 7 years examined we only use 2 acre-feet, that 2 acre-feet number now becomes our appropriation limit. So it's kind of a use it or lose it scenario for lots of landowners. And if we don't use the water at all, in other words, if we've just been sitting on our water rights, then that can result in the water rights being forfeited and going back into the overall pool. So that's our discussion of surface water or stream water. Now let's talk about the process for groundwater. Groundwater use in Oklahoma is governed by what we call the Oklahoma Groundwater Law. Groundwater, not surprisingly, is defined as fresh water under the surface of the earth, so water under the ground. But also importantly, we should note that groundwater is regarded as being outside the cut bank of a definite stream. Because in some parts of the state, especially in western Oklahoma, a significant part of a stream's flow is actually below the surface. And so if we pumped water right at the subsurface of a stream, even though it's technically underground, we would cause the stream to disappear and thus be appropriating the stream water. Note that we consider groundwater to be fresh water, meaning it has less than 5,000 parts per million of total dissolved solids. If water is at a concentration of dissolved solids greater than that, we regard it as salt water. And salt water is generally regarded as a pollutant, not a resource, so we have to be careful about that. How do we get the right to use groundwater? Well, first off, a landowner has the right to take groundwater from the land that they own for domestic use without a permit. And domestic use for the purposes of groundwater is defined in exactly the same way as it's defined for stream water. But if we want to use groundwater for something that's not a domestic use, or if we want to use it in quantities beyond domestic use, once again we have to get a water appropriation from OWRB. And in some respects, the application is fairly similar to the stream water application, but there are some important differences. First off, we have to have an application that shows where we're going to withdraw the water and the precise location of the groundwater well. We have to show that we also own the surface of the land where the well will be located, or that we have some form of legally binding agreement with the person that owns the location where the well will be located. The groundwater use application is going to show where the wells will be located and also show how close they are to other groundwater wells that have already been permitted. They're going to show the amount of water that we're going to take in terms of acre feet again, what the water will be used for, and of course our calculations to show why we arrived at that amount of groundwater need. Additionally, as with the stream water application, we also have to have a notice of application filed. And in addition to that being published in the local newspaper, we also have to mail notice of the application to any surface owner within 1,320 feet, in other words, 1/4 of a mile, of the well's proposed location. Notice of the application that's been published in the newspaper has to run for 2 consecutive weeks, and again, proof of the publication has to be submitted to OWRB. Also, as with the stream water application, if we think there's enough interest for there to be a hearing, then we'll have a hearing held as well for people to provide evidence about how their groundwater use will be impacted if our groundwater use is allowed. Now, the OWRB again has to make 4 determinations, but they're slightly different determinations than with stream water. With groundwater, number 1, does the applicant own the property where the water well will be located, or do they have a legally binding agreement with the property owner? Does our land overlie a groundwater basin or subbasin? And the reason for this requirement is to make sure that there's actually a water-bearing formation that we'll access if the application is approved. Will our water be used for a beneficial use? And again, so long as we can show the water won't be wasted, odds are that we can prove a beneficial use. And we also have to show that waste by depletion or pollution will not occur. That means our groundwater is going to be extracted in such a way that won't permit it to be mixed with salt water or cause the pathway to be created for some other form of surface pollution to get into the groundwater formation and cause pollution there. So how can we go about determining the amount of groundwater that we need? How do we form a groundwater needs analysis? Well, fortunately, OSU has a lot of resources available to help you with this. First off, we have a great tool for irrigation water flow measurement available at the link that you can see there on your screen. We also have some good guides on the fate of precipitation falling on cropland. In other words, this is a way for us to determine how much of the rainwater we can harvest with our crop and what our additional water uses might be. Determination of land use and irrigated crop acres by remote sensing is another very useful publication that we now have available for you from USGS to show you how remote sensing might enable you to figure out how much water is being lost from your irrigated land. And then last but certainly not least, the Ag Mesonet's website has lots of very useful models for us to see how evaporation might be impacting our crops. So all these tools together give you some of the resources that you need to determine how much water you truly need for your crop, and if you're getting all that from rainfall, or if you need a supplemental water appropriation of either stream water or groundwater to accomplish your crop objectives. Now that we've talked about the water quantity issues in the state, let's talk about the water quality issues in the state. In Oklahoma, water quality issues are dictated largely by the Federal Clean Water Act, which is mirrored at the state level. And at the state level, the environmental jurisdiction for dealing with water pollution issues is shared amongst the Oklahoma Department of Ag, Food, and Forestry, the Oklahoma Department of Environmental Quality, and the Oklahoma Corporation Commission, depending on which activity is taking place that might potentially impact groundwater or surface water. If we think someone might be violating water appropriation rules or water potential pollution rules, we can contact OWRB through its regional offices or the state office. And if we think that there's been too much water taken by an appropriation, we can seek some remedies for that, but those remedies are fairly limited. So, as we were mentioning earlier, water pollution is handled by the Clean Water Act. And the goal of the Clean Water Act is to basically preserve the chemical, physical, and biological integrity of the nation's waters. The way that it does that is by establishing a system of beneficial uses for water bodies. For example, if we have designated that a lake or a stream is used as a public water supply, that designation comes with a set of parameters for the chemical, physical, and biological measurement of that water, and we have to make sure that any permits that we issue in the area will not cause an impairment of those standards as measured by those parameters. And the way that we do that is through the National Pollutant Discharge Elimination System, or NPDES. NPDES basically prohibits any discharge, which is a defined term, of a pollutant, which is also a defined term, to waters of the United States, also a defined term. Any discharge of a pollutant to a water of the United States has to have an NPDES permit, or it's a violation of the Clean Water Act. What constitutes a discharge? Generally, if we're talking about NPDES, we're talking about point source discharges. And point source discharges are discharges of a pollutant that come from a definable point. Hence the name point source. Now it's worth noting that a concentrated animal feeding operation is also defined as a point source. Even if the pollutants might run off from a large or wide area of the CAFO, it's still considered a point source and has to have a permit if it's going to discharge any pollutants to a water of the United States. What's a pollutant? Almost anything. Virtually anything discharged to a water of the United States is regarded as a pollutant, and we should note here explicitly that agricultural waste is within the definition. But there is also an important exception to this definition, and that's the exception for agricultural stormwater discharges. If we have a runoff of pollutants from a non-point source in agriculture, such as stormwater runoff from crop areas or pastures, that is not defined as the discharge of a pollutant under the Clean Water Act and NPDES. Note again that CAFO is explicitly defined as being a point source, and so all CAFOs, if they're going to discharge to water of the United States, do have to have an NPDES permit. What's a water of the United States? It's a fairly broad definition, and that definition has been under a lot of scrutiny lately, specifically because of the EPA's and the Corps of Engineers proposed waters of the United States rule. The waters of the United States rule is currently suspended by a federal court while that rule is undergoing review. So in the meantime, we have the existing statutory and regulatory definition, which you see here, which is still pretty expansive. Well, one of the things that we need to figure out then is if we are an animal feeding operation, are we a point source because we meet the definition of CAFO? And this flow chart will kind of help you figure that out. Number one, does our facility maintain animals for 45 days or more out of a 12-month period? If not, we are by definition not a CAFO. Will our facility discharge pollutants to water of the United States? And if the answer to that is no, then again, we cannot be defined as a CAFO. But if the answer is yes, then we have to ask ourselves how many animals we store. And as you can see from the graphic that we have here, there are a number of different thresholds depending on the number of the different types or species of animals that we might house. If we meet those thresholds, then we are required to have a CAFO permit under NPDES. Although it's not a point source, we also have to sometimes be concerned that if we have the storage of oil on our farm or ranch, that if we were to have a leak of that oil, that could also constitute a discharge of waters to the United States. And that's why we have SPCC, or Spill Prevention, Control, and Countermeasure requirements. If we store a sufficient amount of gas or oil on our farm, we might have to have an SPCC plan. It's worth noting at this point in the presentation that there's currently an interim study being performed on the SPCC rules to figure out exactly what the thresholds of compliance would have to be for a farm or ranch. Right now, the threshold amount is 6,000 gallons in above ground storage. If we have 6,000 gallons or more of above ground storage of oil, and oil is defined not only as petroleum oil but vegetable or animal oils also, then we may have to have an SPCC plan. What's in an SPCC plan? First off, we have to show how we're going to design areas where oil is stored to make sure that if there is a spill, we have a structure or berm, sometimes called secondary containment, that will prevent that spill from reaching a water of the United States. We also have to have provisions that explain how we're going to construct those secondary containment areas. And we have to show that we're going to keep oils only in appropriate containers. In other words, if we keep gasoline in containers, we have to make sure that container is properly designed to contain the gasoline without corroding or creating the opportunity for leaks. We also have to have procedures that we're going to inspect for leaks around containers or pipes to make sure that a slow release isn't occurring on our land. We also have to make sure that if we have underground storage tanks, and lots of times those tanks may be metallic, that we have a corrosion protection system in place for those tanks. Sometimes that's accomplished by a process that we call cathodic protection, where a very low-level electrical current is run through the container to make sure that corrosion can't occur. Additionally, if there is a spill, we need to have a facility response plan that shows how we're going to react to that spill to contain it and clean it up if necessary. The plan needs to detail what materials and equipment are available for us to contain and clean up the spill, how we're going to train our employees to respond to spills, and any emergency contacts that we need to make in case that there is a spill. Beyond the Clean Water Act provisions about discharges of waters to the United States, we also have to be concerned about changes that we might actually make to the waters themselves. Now, for the most part, we usually don't engage in a lot of farming operations in streams or in ponds or lakes, but sometimes we do engage in operations in what we call wetlands. And wetlands, as defined in the current version of the regulations, are considered waters of the United States. So that's one thing we have to think about, is if we're going to drain a wetland or fill in a wetland or do anything really within a wetland, whatever we're doing is taking place within a water of the United States. So any release of material into a wetland is almost always going to require a U.S. Army Corps of Engineers 404 permit. And that's a permit that we have to get to discharge any material to a wetland. If you're wondering whether or not your land is a wetland, you can contact the U.S. Army Corps of Engineers and get an official determination so that you can know with a good degree of certainty whether or not you're going to need a 404D permit. Now, quite importantly for farmers and ranchers, the SWAMPbuster provisions of the 1985 Farm Bill which, by the way, is permanent law with respect to the SWAMPbuster provisions, says that we're not entitled to the benefit of any Farm Bill programs if we violate SWAMPbuster rules. So, for example, if we've drained a wetland without having the proper 404 permit and without getting a determination from the Corps of Engineers, we could lose all of our farm program benefits, and that can be a pretty significant penalty. The last thing that we'll talk about in this module is non-point source discharges. Remember, NPDES deals only with point source discharges of pollutants. It doesn't deal with non-point sources. Non-point sources are very difficult to regulate simply because it's difficult to get control over them. But one form of non-point source discharge that can be regulated is industrial stormwater and construction stormwater. Construction stormwater is basically runoff from an area where more than 1 acre of soil has been disturbed. And in agricultural contexts, the Oklahoma Department of Ag, Food, and Forestry issues agricultural construction stormwater runoff permits. So if we're going to have a construction activity on our farm that's going to impact more than 1 acre of soil, then we need to have the general permit issuance for a construction stormwater permit. When we talk about 1 acre, we mean if the entire construction project is going to disturb more than 1 acre, even if there are not 1 contiguous acre of soil disturbed there. Now, it's also important for us to note that normal cultivation operations, i.e. plowing, sowing, those sorts of things, aren't covered. That's not something that's going to require us to have a permit. But if we are constructing agricultural facilities, for example, a feedlot or a barn area, and we're going to disturb more than 1 acre of soil, we do have to have that non-point source discharge permit. So today we've talked about the various forms of water pollution that might come from agriculture. We've talked about how those might be permitted and what needs to be shown to obtain some of those permits. We've also talked about how to get more water in terms of its quantity, how we go about appropriating surface runoff, how we talk about stream water, and how we can talk about groundwater if we have needs for more of that type of water for our operation. So we've covered a lot today, but all this information is discussed in more detail in our Environmental Regulatory Compliance Handbook. Just go to the Ag Econ website at agecon.okstate.edu, click on the Extension tab, and look for our Environmental Regulatory Permit Handbook for more information. Thank you for watching today.